Welcome to The Insurance Lawyer, the podcast where we discuss topics concerning claims and lawsuits between insurance companies and their policyholders. I am your host, Evan Schwartz, founding partner of Schwartz, Conroy, and Hack. The firm represents business and individual insurance policyholders in claims and lawsuits against their insurance companies, helping policyholders get their claims paid. Today, we're going to talk with my partner, Matt Conroy, about professional liability insurance coverage. As anyone a little bit familiar with the wonderful world of professional liability insurance coverage, know that that can take a couple of different names. It can be coverage for malpractice or coverage for errors and omissions, but it basically is coverage for people that are alleged to have made errors in the rendering of different types of services. And Matt here is going to run you through just some of the basics of understanding how these policies work. What we're going to start with is that, generally speaking, in the world of professional liability coverage, most of the policies are what is called claims-made coverage. And Matt, maybe you can explain a little about what that means.
Certainly. So when we're talking about professional liability insurance coverage, whether you're insured or whether you're a lawyer representing insureds, you are a professional or you're representing a professional who is having a claim asserted against them by someone. Sometimes it's, in the legal context with legal malpractice, it's a client, it's a spouse of a client, it's someone to whom you owe an obligation that they're alleging was breached. And the first sort of layer that you look at is what kind of policy are we dealing with? And basically, they fall into the two categories of claims-made policies or occurrence-based policies. And the distinction, which seems relatively obvious, but isn't something that some lawyers always look at, especially people who are not, fully versed in this space, claims-made policy is where your coverage term under that policy is based on when the claim is made. In the claim, these are terms that are defined in the policies, and we're talking about the point where the client or the claimant, asserts its rights against your client, as opposed to an occurrence-based policy where coverage is triggered or based on when the act of negligence itself was committed. For example, if we're talking about in the legal context, a lawyer who makes a mistake on behalf of his client and, for example, fails to answer a complaint timely, which results in a default judgment, which ultimately is not overturned, the act of negligence itself likely occurs at the time that the answer was due. However, the client may not assert a claim against the lawyer or the law firm for several years, so that the date on which the claim was made is very different from the time that the occurrence took place. And so when you're dealing with these matters, one of the things, obviously, that every practitioner should do is get a copy of the policy and read it. It should be pretty clear what we're talking about. But in the professional liability context, most of these policies are claims-made type policies. You also have issues with hoarding. And Evan, maybe you want to address that a little bit.
Well, yeah, we're going to get into one of the thorny issues when it comes to professional liability claims as to when you should tell your insurance company about a, quote, claim, unquote. And I say, quote, claim, unquote, because claim is typically a defined term, and notice of a claim is what is the obligation defined as to when the insured is supposed to tell the insurance company about a claim or a potential claim. But the claims-made policies, they have different language as well. Some will just say the claim needs to be made within the policy year period, which is usually a year. So January 1st to December 31st. They also sometimes talk about claims made and reported. So not only does the claim have to be made within the policy period, but the insured needs to tell the insurance company about it within the policy period, or some defined term that's in or around within the policy period, meaning some of them have a little bit of a tail where they'll give you 30 days after the policy's expired to report any claims. But you have to be aware at least of what your if you do nothing else when you're looking at your professional liability policy, you should at least know generally when you're supposed to report a claim, so that you know if something comes in, you're aware that, ooh, this is something I need to tell my insurance company about. Because one of the biggest problems we see when we're evaluating potential new cases is whether or not somebody properly and timely notified the insurance company of a claim or a potential claim. So, you don't want to pay for expensive insurance that protects you for a potentially very expensive liability and then lose the opportunity to take advantage of that insurance just because you didn't tell the insurance company about it when you should have.
Yeah, it is a thorny issue, and it's something that lawyers who are advising clients on the matter, or the clients themselves, whether you're a lawyer client or whether you are some other kind of professional, understanding your reporting obligations is important, and it's sort of fact sensitive to the particular policy that you're covered under. The issue of giving notice, many people are under the misconception that notice is required when you get sued or when you receive a demand letter from a lawyer. But the reporting obligations are considerably broader than that. When you become aware of facts that would lead you to believe that your client is going to assert a claim against you, even if they haven't actually asserted it, you may be under an obligation to report that to your carrier, and your carrier may then develop defenses to a claim that is formally asserted against you in the future. And lawyers would be cautioned, and insureds would be cautioned to make sure you really understand what your reporting requirements are. And if you're in doubt, report it as a potential claim. I haven't heard of any lawyer being sued for malpractice based on their over-reporting of claims on behalf of a client.
And clients are afraid generally to report claims because they think that their premiums are going to go up. And premiums go up for lots of different reasons. But the reporting of a potential claim, which typically you have the obligation to do, is not necessarily going to drive up premiums. The premium risks that typically relate to cost really have to do to the insurance company spending money. So money that they spend defending you, money they spend indemnifying you, that's where they're really going to be looking at whether or not they're going to charge you more money next year, whether they're going to keep you as an insured. Now, look, if you report everything under the sun because you're so paranoid that you think anything could be a claim, that's not recommended, because if they see too many claims, then they think you're a bigger risk. But, there's a big field in between the two of those, where discretion being the better part of valor a lot of times is report the claim if you really think it's a potential claim. And if you're not sure as an insured, talk to a lawyer that knows this, even just for the purposes of saying, hey, should we report this?
Sure. And understand that the distinction between a potential claim and a claim, the claim itself is largely based on communication from the client or the customer to you. Are they asserting rights? Are they asking for something, either for you to do something or for money? Are they alleging that you've done something improper? The claim is based on conduct of the customer or the client. But notice of a claim oftentimes has nothing at all to do with what the client does or doesn't do. It often has to do with your knowledge of whether or not you've done something wrong. So we frequently see issues where years later, after a claim is asserted, the carrier is looking at, well, if the malpractice is based on your doing something or failure to do something, did you know about that at the time? And were you under an obligation to report that, regardless of whether or not the client knew or made noise about it? So understand the distinction that, frequently the obligation to report a potential claim is based on you as the insured's knowledge of potential bad behavior on your own part. And that's something that needs to be treaded somewhat carefully.
Yep, and we'll talk about that a little bit more because it's such a big issue when it comes to these types of cases. But let's just generally run through just some examples of the type of professional liability insurance coverage that we often encounter. And there are others, but this is a large sampling of what's out there to protect people that are these claims-made type policies. Legal malpractice insurance definitely one. Medical malpractice insurance is one. Directors and officers liability insurance coverage, or D&O, is typically a claims-made type policy. Brokers, insurance brokers, they have errors and omissions coverage, but it's basically malpractice coverage, right? And that's typically a claims-made policy. What we see a lot more of and a lot more going on these days when it comes to the Me Too era and a lot more insurance here is EPLI, Employment Practices Liability Insurance, EPLI, which covers a whole host of things that can be alleged by employees against employers, and those are typically claims-made policies. There are also media liability policies. There's cyber liability policies that can often be claims-made policies. So there's a whole host of different types of claims-made coverage out there that can cover the mistakes that can happen during the rendering of services and professional services. And claims-made policies are popular for a number of reasons for both the insurance companies and the insureds. I mean, the premiums are lower. They can exclude prior acts so that they don't have to worry about things that happened in the past very easily. There's greater certainty when they're underwriting. And again, there's good competition from a pricing perspective. So these policies definitely have value, and there's lots of them out there. And it's important, besides getting into the details of what types of things may or may not be covered and what other disputes come up, to emphasize again that what is a claim and what isn't a claim, what is a potential claim and what is not, and whether or not it's been reported it is what you see most frequently thought about in the court system. And so we've talked about, hey, you need to look at your policy definitions and you need to look at what a claim is, but there are specific examples of what a claim is, and I'm going to let Matt run through what some of those are.
Right. And so as a lawyer, if you're representing somebody and you run into these issues of identifying, is it a claim? Should I put someone on notice? Am I entitled to coverage? Should I be filing a DJ action? You'd be well advised to begin with the policy. Look at the definitions, understand exactly what the facts are in your case, and then do some research and look at what your state and your jurisdiction says, because it's different from place to place. And there are a lot of examples, and they change over time. But typically the general rule is that you're going to find that courts give the policy language its ordinary meaning in its interpretation. And as simple as that sounds, I assure you it's really not the case. And that ordinary meaning is somewhat subjective and in the eyes of the beholder who's wearing the robe on that particular day. But when it comes to defining a claim or looking for legal precedents as to whether something constitutes a claim, I'll just read you a couple of interesting cases. There's a case out of the Northern District of New York where a law firm received a letter requesting information from a lawyer representing their former client. The letter was held not to be a claim because the policy definition required monetary relief or other relief. And so the court ultimately had held that requesting information by itself didn't constitute other relief. There are other cases in other states where they say that where a client is asking for specific conduct, where you're accused of doing something wrong, and as a result of that, you're being asked to do something specific, even providing information that is sufficient to constitute a claim, because it's alleging malfeasance on your part and requesting specific information. So, different jurisdictions look at these things differently, but as a practitioner, you'd be well warned to do some research, understand what your particular facts are in that case, and then come to some kind of determination. Typically in New York, the requirement is that there be either money or services, and services can include doing actual work, as opposed to the case that was cited where we're talking about just providing documents. Evanston versus GAB from 1987 is sort of the seminal case on that, and that's probably a good place to start. But obviously you want to shepherdize and do current research to determine what the current state of the law is. But again, when we're talking about what the claim is, that's going to require some accusation that you've done something wrong and then a demand for either money or services.
Right. So what we're talking about here again is when you receive from a customer, client, or someone who you were in business with to perform some service, reaches out to you and demands money or services, and typically related to a claim that's owed to them because you did something wrong. That's where the quote claim unquote, as opposed to a potential claim where you think you might have made a mistake and you're debating about whether to report it. That's when it's pretty clear that you've got to go tell your insurance company about it. A demand for money or services by a former customer or client, to me, is the quintessential, time to give this to our insurance company.
Right. And in that vein, when you're looking at what constitutes a demand, money or services sounds somewhat ambiguous to me, but an example would be where the client is telling you, you've created this problem, fix it. Even though they're not asking for money, them asking you to fix it, that most likely would constitute a claim in New York. Saying you screwed this up, send me my file, even though it's requesting you to do something, that probably falls under the Evanston case, where they're not asking for damages or compensation or specific services to be performed. They're simply asking for information. And there are cases out there, such as Reliance Insurance Company from 2008, where they basically say no specific request for information will constitute a claim in the absence of some other demand for relief.
Right. But if you have some former client or customer who sends you a letter and says, you screwed up, give me my file, my advice as a lawyer would be, you best tell your insurance company about that, because you don't want some twist in the facts of the demand you've received to now be the next litigation as to whether or not you timely notified the insurance company when you became aware of a claim. That's where I would say, discretion is the better part of valor. Well, there might be case law that says this doesn't constitute a claim, but let's all be real. You've got big time exposure here, or some exposure that you don't want to have to underwrite yourself. Tell the insurance company about it. Let them open a file. Protect yourself.
And that's also a distinction between a claim and being on notice of a potential claim. Whether or not the actual demand for money or services fits within the legal definition from these cases, that may be true, but that doesn't abrogate your obligation to inform the insurance company if you're on notice of a potential claim. And that's an important distinction, and one that people often don't make. If you have any doubt, if you think that you have a client that's out there that's going to sue you, put your carrier on notice. It's as simple as that. Don't get bogged down in, is this a claim? Worry about that later if you get into DJ litigation with your carrier about what the actual letter is that was forwarded to them that they disclaimed on.
Right, but also think about it this way. If you have the duty to inform your insurance company of a potential claim, and you receive a letter like that, even if that's not a claim, it's probably a potential claim, because it's now you have knowledge or belief that maybe you screwed something up. And maybe you've now triggered the duty to tell them about a potential claim, even if it's not technically a claim.
So it's certainly conceivable that you received this letter saying, Attorney X, you've committed horrible mistakes on my behalf and you're fired. Please send me my entire file. You send them your file, and then 1 year later, you get sued. And you then take the summons and complaint, forward it to your carrier saying, please defend me. I take this as being a claim. And your carrier says, well, let's investigate. And they ultimately get a hold of the original letter demanding the file. And they say, well, you didn't tell us about this. And your position is, well, I didn't deem that to be a claim because they weren't asking for money or services. It wasn't a demand. And your carrier says, well, that's not really important. What's important is that you knew that they were going to sue you. you knew that you had made a mistake, potentially, or at least you knew that the client believed that you had made a mistake. And so even though it doesn't constitute a claim, and we accept that it doesn't constitute a claim, we believe that you were on notice of the claim and you had an obligation to report that to us. So it is very possible that you could have a letter or a demand that does not constitute a claim, but does constitute notice of a claim. So or
notice of a potential claim.
Potential claim. So
right.
In the event that you have any doubt or you're not sure, one, you should probably talk to somebody about it, but really, you should probably just put your carrier on notice.
Right. Now, so in the practical sense, if you're going to look at doctors, lawyers, and brokers, the likelihood that you're going to get letters demanding things and asking for money or services is much more likely to come up when you're a broker or a lawyer, and much less likely to come up with when you're a doctor. Generally speaking, if someone thinks medical malpractice has been committed, they typically don't send a letter to the doctor and threaten them. They typically get the medical records and give them to somebody else and maybe talk to a lawyer to see whether or not they have a malpractice claim. So doctors are much less frequently confronted with this, hey, is there a potential claim and do I need to put the insurance company on a notice of a potential claim, than lawyers and brokers. So when we see litigation about these questions of whether a claim or a potential claim existed prior to the time that you, the insured, put the insurance company on notice, they're typically not cases that are litigated involving healthcare. So that's just a tidbit about the realities of how things work. So there's plenty more to be explored about this, but for now, understanding that these policies, how they work in general, and understanding the importance of understanding when you as an insured may have to tell your insurance company that you might have a problem are really the most important things for you as an insured to understand in the professional liability world. So I want to thank you for listening today. And if you like the podcast, make sure to leave a review and subscribe so you don't miss an episode. You can visit Schwartz, Conroy, and Hack PC website at www.schLawPC.com. That's www.schLawPC.com. For more information, feel free to check it. And I am the insurance lawyer. Have a great day.